It is my pleasure and great honor to introduce Professor Robert Post, who is the Sterling Professor of Law at Yale Law School. He was formerly the Dean and the David Bois Professor of Law at Yale, and prior to that, he was the Alexander F. and May T. Morrison Professor of Law at the University of California, Berkeley School of Law. He holds a Bachelor of Arts and a PhD from Harvard and a JD from Yale Law School, and is the author of numerous books and countless articles on constitutional democracy, freedom of speech, and academic freedom. And all you have to do is go to his website and look at his CV. I could not even begin to list them in the time we have allotted for his actual talk. He has been honored with numerous awards and prizes, including the Corat Israel Prize, fellowships from the Guggenheim Foundation and the American Council of Learned Societies, and the Hughes Gossett Award for the best article in the Journal of Supreme Court History. He is also a fellow of the American Philosophical Society, the American Academy of Arts and Sciences, and a member of the American Law Institute. I could continue in this vein, but truthfully, none of this captures the enormous influence that Professor Post commands, right, in the respect. He is truly one of the most influential, thoughtful scholars working in the First Amendment area today. His work on civility, academic freedom has been widely read by, I suspect, every First Amendment scholar who starts out and who continues to work in the area. To be immersed in Professor Post's work is to come to know that you are in the presence of someone who is really a whole lot smarter than you are. Someone who is worth reading and listening to because you can't help but to come away better for it. And I have returned to his articles again and again. I have a notebook in my office that says Robert Post on it, and it has his articles in it that I return to every time that I write. Professor Post is also, however, a gracious and a giving mentor. As a young, untenured professor, he willingly read an article of mine that someone else gave him because I would never have had the temerity to send it to him. And he gave me lengthy and constructive criticism. I've never forgotten his generosity. It made my article much, much better. But he did that for someone he did not know and for someone who had no reputation at the time. So he is generous and giving, and I suspect he hasn't forgotten that he did that for me either, because I continue to bother him for his thoughts, and he continues to respond graciously. So without further delay, I give you Robert Post.
I want to say you couldn't ask for a sweeter introduction than that. Thank you, Chris. And thank you, Larissa, and thank you, Bob, and thank you, this wonderful law school, for the opportunity to be here. You've put together a really wonderful conference to watch how these problems play out in their concrete detail and in the events that actually happen. That's a priceless gift, to be able to learn all of this and to talk with the people who had the baptism of fire that we heard this morning, and I suspect we will hear again throughout the rest of the day. In answer to your question, where's Bob? About Charlottesville. Charlottesville, to me, is a question of the public sphere. It's a question of the First Amendment proper, about how we deal with each other in the public square. And one of the things you heard, a metaphor you heard this morning a lot, was of the university, particularly the large public universities like Missouri or Auburn, as a public square. Now, of course, they can be made so by statute, but putting apart statutory obligations, the thesis of what I'm going to say today is that actually universities are not the public square. They're really quite different kinds of places, and you saw that in the presentation very explicitly in the presentation not only of Middlebury, which is a small private, but in the presentation of Auburn, which is a large public, namely when the discussion about how, when Taffy and Julia were discussing how to handle this crisis, they put at the top of their matrix values. There were values that Auburn stood for, and that's what guided you in determining how to handle the situation. That makes you, in my lexicon, a community. The public sphere is a sphere of strangers. It's a sphere where we decide what our values are, But a community is an institution that already has values. Those values are connected to learning, to education, to the expansion of knowledge, and so forth. And we are guided in how we conduct ourselves, which means how we speak, by those values. And that puts us in an entirely different realm than that constructed by standard First Amendment doctrine. So don't take me, when I say these things, to be giving you advice as a lawyer. Judges can say anything, and I'd have to look at the facts of your case. I'm going to talk about how the First Amendment should be construed, and when you get decisions which on their surface appear to be contrary, like in Auburn, I think there are pretty good explanations for that. My role in this conference, therefore, is going to be largely negative, because I know a lot of you in universities, particularly public universities, are being told, well, the First Amendment requires you to do this. This is your responsibility. Under the First Amendment, we see a new book by Dean Chemerinsky and Provost Gilman to that effect. We see, I know Azir is here representing FIRE, who will say the same thing. The First Amendment governs you in your handling of these situations, and I'm here to say, not so fast, not really, and not that First Amendment which you are imagining to be the governing constitutional instrument that will constrain your ability to deal with these things. There's many more steps that you have to think about before you get to that conclusion. So how to do that? Well, what is the First Amendment anyway? I mean, if we say the First Amendment applies, what are we talking about when we say freedom of speech, meaning the First Amendment? First Amendment is a compendium of rules and doctrines. Fred Schauer, the great scholar, used to say it's like the tax code. You know, it's got so many provisions you can't really figure it out. And it's true, it has many. But you can, let me just take 4 of them, which are so essential that if you don't have these 4 rules, you don't have the First Amendment. Just, they're at the core of the thing. So the first one would be no content or viewpoint discrimination. The court has endlessly said, if the First Amendment means anything, you can't discriminate on the basis of content, you can't discriminate on the basis of viewpoint, you can't let one view be said without, you can't make these discriminations based on viewpoint. The second rule, all ideas are equal. This is often equated to the marketplace of ideas. The state can't intervene to stop the marketplace of ideas on the grounds that some ideas are true and the other ideas are false. There is, as the court said in Gertz, no such thing as a false idea for purposes of the First Amendment, and that's a central concept which underlies what we attribute to Holmes, the metaphor of the marketplace of ideas. Third rule, state can't compel you to speak. The freedom to speak is accompanied by the freedom to remain silent, no compelled speech. And the fourth is, it's a bedrock principle, says Brennan in Texas versus Johnson, that you can't censor an idea merely because it's offensive. Offense is not a grounds for suppressing speech. That's just, we have to live together and be offended by each other. Let me just, now let me just give, these are very powerful rules, some explanation about why it is we might have rules such as these. And I want to point out first that these rules didn't exist. First Amendment doctrine didn't exist. First Amendment didn't exist as a charter of judicial protection for speech rights until the first third of the 20th century. First Amendment is ratified 1791. No Supreme Court opinion ever thought about protecting freedom of speech rights. The first time any Supreme Court justice ever conceived that there might be, and this is in dissent, protection for First Amendment rights is in November of 1919, and the first time the court ever protects First Amendment rights is in the 1930s. So we're dealing with something relatively recent. The court, for the past 80 years, has been trying to think through the implications of protecting speech. It's hard to do because speech is everywhere. So as you fashion these rules, you're fashioning rules for a lot of things. If the trigger for First Amendment coverage is understood to be expression. So why did the court eventually, by our time, come to settle on these 3 rules? The answer is something like this. The First Amendment begins to assume the shape that we recognize now because the meaning of self-governance in the United States, self-government, self-determination, changed in the progressive era. We always understood ourselves to be a form of government that was answerable to the people, but what it meant to be answerable to the people until the progressive era was you voted for a party and the party represented your interests. So you were represented by a party. By the progressive era, parties became corrupt. People no longer thought that the party spoke for them, and they longed for a more direct relationship to their government. That's why you had the direct election of senators, you had institutions like the referendum and the initiative and so on, all instituted in the progressive era to bypass the party. But if the party no longer summed up what it meant to be self-governing, you were Republican, you were Democrat, you voted for the party, how did the government become responsive to you? And suddenly we began to understand ourselves, and this is different, as a government that was, in the famous words of Lord Bryce, a government by public opinion. All of us were free to participate in the formation of public opinion. The government was now responsive to public opinion, whether or not through a party, and therefore the government was responsive to you. So in the progressive era, we were no longer just a republic, we became a democracy. We became a democracy because the government was responsive to each of you through your potential exercise of First Amendment rights, participation in the formation of public opinion. And so, as the court said in its very first important First Amendment decision, a case called Stromberg, we protect First Amendment rights so that the government could be answerable to the will of the people, meaning the public opinion formed by all of you talking in the public sphere. Remember, we were talking about the public sphere this morning. The public sphere is where public opinion is formed. The word public is absolutely crucial in the history of First Amendment doctrine and remains so. Okay, so that's the fundamental idea. First Amendment is created in order to allow the American people to exercise self-governance, to find out and discuss with themselves about public issues of the day, and to make the government answerable to what they want after these informed discussions. So how do these four doctrinal rules respond to that mission? That's the mission, that's the point of First Amendment protection from 1931 to the present. How do these rules respond to that? So the idea of no content discrimination. Well, if what we mean when we say that the government can't exercise discrimination by content is that public opinion should create the agenda for the government shouldn't create the agenda for public opinion. So if people want all of a sudden to talk about regulating the NFL, they should put that problem on the agenda of government, and government should be responsive to what people want. The government can't say in advance, can't talk about the NFL and take it off the table for things that, for a subject matter that people want to talk about. So the idea of no content discrimination is basically who sets the agenda for government action. It's the people in their participation in the formation of public opinion, not the government and the rules it lays down for what content can or cannot be laid before the public. What about the rule about there being no such thing as a false idea or all ideas are equal? Alexander Micheljohn put this differently. He said there's an equality of status in the field of ideas under the First Amendment. That's what he said in his great 1948 book on political freedom. Well, that represents the notion that all of us, as democratic citizens or participants in the democratic process, are equally entitled to influence the government. We're equally entitled to have our views laid before the public, to try to influence public opinion, to be responsive to what we think. No one is better than us. John Rawls, a philosopher, once said, in public discourse, in discussion among people about what we should do publicly, there is no expertise. The philosopher's opinion isn't worth more than your opinion or my opinion. We're all equally citizens. And that is the notion of political equality that's at the heart of a democracy. And that is what underlies the equality of status for the field of ideas. Notice this is a political equality, not an epistemological equality. To say every idea is equal to every other in terms of truth value is nonsense, because it would mean we wouldn't ever know anything. We'd always be back at square one. No one really thinks that, certainly not a university. But as a political matter, it makes a lot of sense to say every idea is equal to every other, because in the public sphere, we are politically equal, because we live in a democracy. That's the second rule. Third rule, which is I can't compel you to speak. Well, the state is supposed to be answerable to you, to your views, to your perspectives. If the state is making you talk, it's obviously not being responsive to what you want to say, because you're being made to talk in ways you don't want to talk by hypothesis. So the freedom to speak equals the freedom not to speak, because the whole point of speaking is the virtue of self-governance. The state should be responsive to you. And finally, this value of this importance of not regulating speech because it's offensive is a striking rule, by the way. We're the only country in the world that has a rule like this. If we speak about American exceptionalism, we have to speak not merely about the Second Amendment, but about this rule in the First Amendment saying speech cannot be regulated merely because it's offensive, outrageous, indecent, vituperative, or something like that. Why do we have such a rule? This has something to do with cultural heterogeneity in the United States and the difference between a public and a community. So this rule develops at about the same time that American sociologists are studying the city of Chicago. And they say, city of Chicago is a really interesting place. It has all these sub-communities. There's Little Italy, there's Little Poland, there's the Jews here, there's the African Americans there. And each little sub-community has its own norms about what's right and not right to say and to do. But the whole city of Chicago transcends any different community. The public sphere of Chicago is the combination of all of these communities, and therefore has to be greater than any single one of these communities. So the question of what is outrageous, the question of what is offensive, is always determined by reference to a community. It's by reference to the norms which you grew up with, which you consider proper or improper. That's how we know what's offensive, because different communities will regard different things as offensive. We know that. So if you want to construct a public sphere which encompasses many communities, then you can't allow any single community to impose its norms on the whole. We have to be a place, as the court said in an important decision called Cantwell, where many forms of communities can grow and thrive and deal with each other. So once again, here we have this notion of equality of communities within the public sphere, meaning no single community can impose its idea of offense. So these four rules make a lot of sense when we apply them to the public sphere, which is the natural home of the First Amendment. And now the question is, what is their application to the university? I mean, when people say to you the First Amendment applies, do they mean this First Amendment? Now, there is a First Amendment that applies to every public university. I'll talk about that in a minute. But when people say in the modern controversies, when Jeff Sessions says that freedom of speech is in retreat in universities, and of course has to apply to public universities like Missouri, and the essence of the First Amendment, he says, quoting Scalia, is no content discrimination. He means the First Amendment of these four doctrinal rules that I just described to you have to apply, and I suspect FIRE does also, although I live to be corrected. So do these four rules apply? First thing to observe about this is that these four rules are meant to embody a world in which we are equal as political citizens and we're governing ourselves. The university is not such a world. The university is not political at root. It's an institution dedicated to expanding knowledge and to education. This is not a political process. It's a process of how do people learn, and it's a process of making knowledge. These are very different kinds of issues than concern the public sphere. Second, it concerns forms of political equality. University is not a scene of political equality. You know, if I'm in the classroom, there's no political equality between me and the students. I'm governing a classroom. So whatever you want to say about a university, in its root, it is not an institution formed in the same way as the public sphere is, as the First Amendment conceptualizes the public sphere. And so saying that, it would be shocking as a sociologist if these four rules, which create a sphere of democratic equality, would apply in any meaningful way to the university. So take an example, very simple example, just the essence of a university. Take the classroom. Just take a classroom. So first rule, no content discrimination. Of course there's content discrimination in the classroom. You know, if I'm teaching a class on constitutional law, my students are not going to be talking about the World Series. End of story, right? Second rule, all ideas are equal. Is that true in my classroom? You ever hear of grades? My job as an educator is to teach the students between good ideas and bad ideas. That's what education is. Discrimination between better and worse, between true and not true. That's what I'm there to do. That's incompatible with the second rule. Third rule, no speech. It can be compelled. Okay, I don't even need to go there, right? You got it. What about the fourth rule, no offense? Well, here's a little tricky, but no student in my class gets to call another student names. They don't get to be personally offensive. They have to abide by rules of civility. Why is that? Because otherwise you can't have an educational setting that's effective. This is the same reason why, for example, in the United States Senate or in the House of Commons in Great Britain or in the Canadian Parliament, you can't cast personal aspersions on someone else. Remember when Elizabeth Warren was censored by Mitch McConnell because she dared to cast personal aspersions on Sessions during his confirmation hearings because she read a letter by Coretta Scott King? Remember that? These are rules that these bodies make in order to have deliberate debate. Same in a classroom. No one gets to call names. Now, that means separating a concept of offense, like you may find this idea offensive, but you have to deal with it. So offense at an idea versus offense person to person. Now, the First Amendment protects offense person to person. I get to call you all kinds of names under the First Amendment, short of something called fighting words, which is very narrow, tiny category. But I don't allow that in the classroom. No responsible teacher would allow that in the classroom. So none of these rules apply in the classroom to the student speech. What about my speech as a professor in the classroom? I'm a participant too. Do I get those First Amendment rights? No. Content discrimination. If I'm hired to teach constitutional law, I better teach constitutional law. What about no idea is a false one? Well, if I'm a math teacher and get my equations wrong, I'm in problem, in front of that classroom. I better learn that the First Amendment was ratified in 1791 and not 1789. And if I keep getting it wrong, I got a problem. Third rule, compelled speech. I better show up for class. I better not sit at the class and not talk. I have to actually speak. And the fourth rule, not offense. It's part of my job not to personally insult my students. In point of fact, that's in the Professional Code of Responsibility from the AAUP, every professor. If you personally insult students in ways that are offensive, in ways that are categorically protected by the First Amendment, I can be disciplined and appropriately disciplined. So they don't apply to me in my speech in the classroom. What about another core aspect of the university? My capacity as a professor to do research, to increase knowledge. Now here you have a little bit more complicated problem because we're all used to this notion of the marketplace of ideas, and the marketplace of ideas is how you increase knowledge, Now I want to say to you that's actually 100% totally false, because there is no, how do we increase knowledge? What is knowledge? We certify knowledge by expertise. So if I want to know what the half-life is of polonium, I go to an expert and he tells me or she tells me what the half-life is. If I want to know whether nicotine causes cancer, I go to an expert doctor and they tell me what the studies are. They don't go to a marketplace of ideas. You don't put it on the internet and get do a monkey poll. That's not how you find out the answer. If you want to know whether the bridge can take the stress, you go to a civil engineer. You don't go to the marketplace of ideas. So actually, our modern notion of knowledge depends upon expertise, and expertise is disciplinary. That means you study hard, you pass tests, you get certified as an expert. So the university is the site of disciplines. Universities create disciplines, they nourish disciplines, they advance them, they are the home to disciplines, they certify what is and is not disciplinary. And nothing in a discipline works according to the marketplace of ideas. If any of you edited a journal like Lancet or Nature, Do you think they do that by the marketplace of ideas? No. They send them out to readers and say, what's good, what's bad? Judgments of disciplinary competence are made all the time. So in my capacity as a professor, do I get tenured based on the marketplace of ideas? No, I get tenured on evaluation of the quality of my work. Do I get hired based on viewpoint neutrality? No, I get hired based on an evaluation of the quality of my work. So there is no content discrimination. There is content discrimination continuously on my work as a researcher. There is the idea that there is all ideas are equal is a premise that is rejected root and branch, because if there were no such thing as a false idea, there would be no such thing as a true idea, and the whole aspiration to knowledge couldn't get off the ground. That's just skepticism. So all of disciplines are based on the idea there are better and worse ideas. And in my capacity as a researcher, can I be compelled to speak? Did you ever hear publish or perish? Of course I can be compelled to speak, because I am there in my capacity as an expert, and I have to provide the evidence that my expertise is justified. And what about offense? That's a more complicated question, and really, I don't really know how to answer that with regard to my work as a researcher. It is the case that I cannot be judged on the fact that my research causes offense insofar as it's dealing with competent ideas. That I would say, that does apply, but it's a little hard to translate this idea of personal offense to my research. So let's put that one to one side. But here, I've given you core examples of how a university functions in a classroom to educate and in research, and none of them correspond to these First Amendment ideals. In fact, if you said the First Amendment applied to Missouri, and you mean by the First Amendment these core doctrines, which anyone who knows anything about the First Amendment would say are at the essence of the First Amendment, University of Missouri couldn't function. Couldn't hire and tenured faculty, couldn't conduct a classroom, couldn't advance knowledge in its medical school, couldn't do any of the things that we want a university to do. So what in the world could people have in mind when they say the First Amendment applies? What are they thinking? They must have in mind something very different, but what is that? You know, when I've said these things before, and I've said them in blogs, and FIRE is very upset at me because they say, well, we've never, ever taken a case that disputes professors' control over the classroom, you know. Classroom speech is, of course, not protected by this First Amendment. Okay, I mean, that might well be true, but then the question is, for an organization that says the First Amendment applies, why is that true? Why is it the case that the professor's speech, that the admission of the university to educate trumps First Amendment in the classroom? Because by hypothesis, it does trump the First Amendment. And the answer is because the university exists to educate. And everything that the university does as an institution is for educational purposes. And if the university is spending its money for purposes other than education or research, it's on a frolic and a detour, and it's wasting public resources. I mean, the university doesn't get to spend money because it likes to. It gets to spend money because it's accomplishing its mission. What is its mission? Its mission is going to be research or education, unless there's some other specific legislative mission given to a university, but generically speaking. So that means that in every instance that the university deals, it has to deal with, this mission of education has to come forward, and therefore it has to trump these First Amendment requirements, just like it does in the classroom. Because presumably, even the staunchest defenders of the First Amendment will concede it in a classroom where it's obvious to anybody you can't have these rules. So then it'll come up in a different context. It'll come up in the context of student-invited speakers, which we've seen many of these issues actually come up with. So let me just talk about that in a second, but before I do, I don't want to be heard as saying there is no freedom in the classroom and there's no freedom of research. There's academic freedom. And academic freedom is a totally different concept than First Amendment freedom, and it's different in many dimensions. The first is academic freedom is the freedom to act in a professionally competent way. So my academic freedom in the classroom is extremely broad, but it's limited by judgments of competence. I have to be acting in a professionally competent way as a teacher. And that is the meaning of academic freedom in the classroom. I have academic freedom of research. And this, again, is limited by judgments of professional competence. As the AAUP declares in its 1915 Declaration of Principles of Academic Freedom, it is not the privilege, academic freedom, of the individual scholar, it's the freedom of the academic profession. It's that I, as a scholar, will not have my scholarship judged by what the lay trustees or curators think of it, or what the lay public thinks of it. It'll be judged only on the basis of what my professionally competent peers think of it in terms of its professional competence. That's what academic freedom is about. This is not a First Amendment right. It's not an individual right. It's the right of the community of experts, of teachers, and of scholars, and it is not a right as to which any of these four rules that I've just articulated would have any relevance whatever, except insofar as they go to professional competence. So just so I'm clear, we have forms of freedom in the university, deep and important forms of freedom, but they have a different structure than First Amendment freedoms. Now, the issue about student-invited speakers is really interesting because, of course, they are orthogonal to questions of academic freedom. So if questions of academic freedom arise with respect to outside speakers, they typically will settle the problem. So a simple case, you're a professor, you want to invite somebody to your classroom, it's very controversial, the administration is afraid of a backlash, they say you can't invite that speaker. Academic freedom says something about that. It says within the university, you have to defer to the professional judgment of the professor about how to teach. This invitation is part of how to teach, and therefore the administrator should back down. Now, notice all of that logic is within the instrumental logic of the university. It's all about accomplishing the mission of the university and whom is entrusted with the task of accomplishing it, not the lay trustees, not the administration, but the professionals, the teachers, the scholars, and so on. So that's how an academic freedom analysis would function in that case. But if I have student-invited speakers, it's very hard to get any academic freedom analysis at all because students are not professionals. They're not entrusted with anything. So you get a student inviting somebody, and here I'm talking students, much less an outside group in Auburn. I don't know why they have the capacity to ask anybody from the outside, but that's an administrative decision that you make at the outset. But let's assume we have a student-invited speaker, and that student-invited speaker is going to cause controversy. How do you analyze that? And here, the interesting point is academic freedom is not going to offer you any help at all because the students aren't part of the academic freedom analysis, a typical academic freedom analysis in the university. So how would you analyze that under an understanding of what the purpose is of a university? So one understanding is the university is the public sphere. Students get to invite whoever they want, end of story. That would look like the First Amendment analysis that we see put on the table here often. Well, if the university wanted to create those rights in a student, it could do that. And there might be reasons for a university to do that, which we can talk about. But the university needn't do that because the whole point about empowering students to invite speakers in the first place must rest on the judgment by the university that empowering students in this way serves an educational purpose. Because if it didn't serve an educational purpose, why is the university spending its resources to invite outside speakers? So I start with the premise that the university isn't a park. It isn't a space open to the general public. It's not there like a gas station that anyone wants to fill up their car can come and do it. The university is there to educate. And therefore, if the university is giving the authority to students to invite speakers, it's doing it for an educational reason. The question is, what is that reason? And I would say, my observation watching these cases is that the university radically under-theorizes why it does this thing. What educational policies are supposed to be served by giving students blank checks to invite speakers. It doesn't, I can think of several it might do. For example, a public university might want to train students to exist in the public sphere. So it creates a kind of mini public sphere by allowing any student group to invite any speaker, and students on the campus have to learn to live, as they will in real life, with people who disagree with them and whose ideas offend them. I mean, that's a perfectly justifiable educational policy, and that might be the policy, but then it's going to have a number of consequences. But whatever it is, the invitation to the speaker has to serve an educational purpose. Now, if that's true, it also means that the invitation to a speaker can undermine that educational purpose, and that the relationship of the speaker to the educational purpose should and can be always subject to reevaluation in light of the accomplishment of the educational purposes of the university. And First Amendment rights don't do that. First Amendment rights create a structure in which there's no educational purpose at all that's being involved. You just have rights, and that's the end of the story. What we need here is a structure of analysis that goes to the purposes of education, where the default rules ought to lie, how we ought to analyze this in light of those purposes. And that, to me, is the essence of the matter. So I've done here, from your point of view, as to say how you settle these problems, almost nothing. The only thing I've said to you is don't be bullied by people who say to you, you're constrained to do this by the First Amendment. No, you're not. In point of fact, you can create the structures, the educational structures, that serve the ends of the university, which you have to think what your ends are. You know, there are different colleges that in the private sector have very different ideas of what education is, and they can go their own way. First Amendment rules have implicit in them nothing about education. What they have implicit in them is an important and fully fleshed out theory of self-governance. And that's an important thing, but that's not the university. Unless you choose to make it so, in which case then you have to live by those consequences. Now, there are some who say, there's a recent book, Erwin Chemerinsky and Howard Gilman just published a book about a month ago, that says this analysis is fine for what they call the work relationship, that was their word, between the university and students, meaning in the classroom. But outside the classroom, First Amendment, and particularly in a public university like Missouri, First Amendment should apply. And I think that's just wrong. This is a simple example here. At my university, students went around shouting, yes means, no means yes, yes means anal, right? And they were disciplined for this. There's no question but that chant would be protected in a public park. It's nothing, that violates no First Amendment rule to chant that. But if they're students marching around the campus, a university, and it's outside the classroom, has every right to discipline those students. Why? Because, as I started out by saying, university is a community. University is an institution dedicated to a purpose, and it can, and everything, and all the members of the university are part of that purpose. They have obligations and responsibilities because they are part of that purpose and part of the university's community. And if they act in ways that are inconsistent with the attainment of that purpose, like marching around and chanting that in front of the Women's Center, they can be disciplined. So that's a total different point than the First Amendment, which is not taking account of institutional purpose, which is taking account only of the political equality which exists, and we have no other ties in the public other than our political one, but we have many other ties in a university. We have many other obligations and responsibilities, and as we analyze that, it permeates everything that has to do between us and its constituent members of the university. Now, I don't mean to be heard to say there aren't limits to that. I mean to say that the ability of the university to regulate the speech of its students should coincide with the reach of its educational control over students. And there are limits to that. There's a case called Pickering in the United States Supreme Court, which basically held a school board that wanted to fire a teacher who had opposed in a city council meeting a bond issue by the school board, couldn't do it, said the court, said Marshall, because the relationship of the school board to the teacher was just like that of any other citizen. It had no special connections to the teacher's employment relation. And the same is true with regard to students. In the old days of the free speech movement at Berkeley, many people wanted Berkeley to punish the students who had left the campus in 1963 and 64 and participated in the sit-ins. And Clark Kerr, to his everlasting credit, said, no, that has nothing to do with the educational reach of Berkeley over these students. And that's correct judgment. So there are limits, and these are contested limits. In part, it's contested limits now because many students are asking, in my view, for a resumption of in loco parentis authority.
for universities. And insofar as the university is stepping back into the shoes of parents, its educational reach over students will go much broader. And therefore, its ability to regulate students will go much broader. You see this in that famous case about the fraternity on a school bus going on a trip. And to me, that's an argument about what the legitimate purposes are of education, of higher education in the United States. And I think that's going to be debated out, and it's going to be debated out in these First Amendment cases as well as other places, because the First Amendment cases will, in the end, reflect an understanding of the reach of public education, the meaning of public education. And when I say these things, when I say that if the First Amendment applies on a public university campus, it will be subordinate to the institutional mission of that campus. This is not a form of analysis that's unique to universities. I just want to conclude with this thought. Universities don't get the privilege of being the only institution like that. Any managerial domain created by the state will have a similar First Amendment structure. So to put it very schematically, the public sphere is where we decide what our ends will be as a country. And so we have very strict rules about the state's ability to interfere with our end formation, with the idea of what our values will be, what we want to accomplish, what we want to use the government to do. But suppose we decide we want to use the government to do something, suppose we decide we want to use the government to create a healthcare system, God help us. If we make that decision, how do we do that in the modern world? Well, in the modern world, the only way you do that is to create an organization that delivers healthcare or delivers Social Security or delivers a court system or delivers military defense or delivers prison. Anything we do as a country now is done through an organization. So what is an organization? It's a place in which an end is given and all the resources and the people within that institution are dedicated to the attainment of that end. So in a prison, everything is dedicated to security, punishment, retribution, re-education, whatever the prison is there to do. Same in the military. What does that mean? That means for the institution to work, it has to regulate the physical resources and the people within it to be effective in the attainment of its end, and that means the regulation of its speech. So in all of these, what I would call managerial domains, you see the regulation of speech routinely in order to attain the end for which the organization has been created. You have to have that, or the public sphere would be ineffective. It would be neutered, because it could never attain what we want to use the public sphere to learn what we want to attain. And an institution like the university is a simple example of that. So is a public school. These are, so it's an example of a much broader phenomenon. We're not saying anything particularly special about a university when I've made the argument I've made for you. It's a very common phenomenon, actually, in First Amendment doctrine. So I'll just stop right there.
Thank you, Professor Post. That was terrific. For those of you who have questions, if you want to come to the middle, that would be terrific, and ask them in the microphone. I don't know if I have many, but I would like to ask other people ask questions if they have them. Oh, could you introduce yourself before you, and just...
Can you all hear me? Sorry.
Yes.
Good morning. My name is Jamie Crockett. I'm a double master's candidate here at the University of Missouri in Public Affairs and Journalism. Thank you all for the time and putting this organization and this symposium together. My question is simply related to the technological advancements and how that influences free speech and how a university responds to it when it incites fear on campus.
Well, Larissa is better able to answer this question than I am by a long shot, but I will say that and so you're talking about social media, I take it. So you see this in lower school cases. So it used to be that you could regulate a student's speech, say an elementary school or a high school student speech, in the campus, but when they go home, they can say what they want. Now you get cases where the student goes home, they blog about the high school principal, and you get judicial decisions basically saying the managerial domain of the school extends to the home of the student because of the relationship between the social media and on-school activities. These tests are very vague and not well thought through, but the instinct of courts is to imagine the boundary of an institution is always normative, and it's always non-spatial. It's where you want this managerial authority to have precedence over your capacity to function as a citizen or as a person who is not merely a student. You see, because of these social media, a distinct tendency by courts to expand the educational authority of institutions at the lower level, and I suspect you will see it at, certainly true in higher education. And so as a constitutional matter, it's going to go, the authority of the university or of a school to regulate social media is going to expand simply because the interactive effects are so obvious. That's a prediction.
Thank you.
My name is John Landy. I'm a retired professor here. It's a great presentation. I am not a First Amendment scholar by a long shot. So there are two things that I'm wondering about. First is, if, given what you've described, it sounds as if you're saying that the First Amendment wouldn't apply to a public university under this managerial domain theory at all, and yet you also acknowledge, I think, that in fact legally it does. So I'm confused, which is not an unusual situation for me. The second part is, again, I've been to law school, and I remember learning about the First Amendment. It was interesting to hear your theory about the purpose being the governance. And I guess I'm curious if there are other competing theories about what the First Amendment is about, and if you could describe what those are and why yours is better. Thank you.
Wonderful questions. All right, so yes, we know that the First Amendment applies to a public university, but now we have to say, what is the First Amendment? It's like, two ships with the same name, but they happen to be different ships. So when people in the present controversy say the First Amendment applies, they mean the First Amendment of no content discrimination, like Sessions. They mean no such thing as a false idea. They mean the toleration of offensive speech. They mean no compelled speech. That's plainly false. On the other hand, the First Amendment does apply in the sense that it's a public institution. First Amendment applies to any action by the state. So in what sense does it apply? And what I was offering you a theory was the First Amendment applies to managerial domains insofar as it requires the managerial domain to regulate only in the service of the achievement of its institutional goals. At the margin, it requires some second guessing of what those goals can and cannot be. So one of the early school cases is a decision called Tinker by Abe Fortas, who said, well, whatever schooling is in the United States, it can't be a school for totalitarianism, he says, literally. The student can't be the closed circuit recipient of whatever the state wants. So there is, in fact, debate among the justices about what a theory of education should be for the United States. And in fact, there are three basic theories of education on the table. This is largely occurring in the context of elementary school and high school education. One you might call civic education. So the court has allowed the regulation of speech to teach civility, to teach not being offensive. Those are a number of Berger Court opinions. Second is democratic education. The court, you can only educate to be a democratic citizen, meaning you have to tolerate all of this stuff. And the third is what I would call critical education. You can educate in order to teach people to be analytically aware and masterful of what they have to deal with, like a democratic citizen should. Mostly with respect to higher education, it's this latter, insofar as there's anything explicit. But the First Amendment, but you can do whatever is necessary to attain that. Now notice that the First Amendment of the first kind, of the no content, has no theory of education. This other has to derive from a theory of education. So it's a completely different kind of constitutional case that we're dealing with. So that's your first question.
Can I follow up? I
Yeah.
guess I'm still missing, under your theory, how, you acknowledge that the First Amendment does apply to public institutions like the University of Missouri, but I don't see it. Can you be concrete? And maybe I'm missing
Well, here's an example. We saw it out of Auburn. So you're a public institution, and you now have said, as a public institution, it's consistent with my educational theory that I'm going to let this auditorium be leased to whoever wants it, first come, first serve. You've created what we call technically a limited purpose public forum. Suddenly, you can't turn around and change that. But the premise that leasing that auditorium to anybody on a first come, first serve is consistent with your educational purpose has been set by the University of Auburn or by the University of Missouri.
And if they decided not to do that?
Yeah, they didn't, you didn't have to make anything available to the public. Or you didn't have to allow student groups to invite anybody. Or you could do it in the following X, Y, Z ways, right? If you make a theory that it's consistent with your education, you need to make the predicates. That's what I mean to say. Right? So your second point, what are the other theories? There are basically three theories on the table for why we have First Amendment rights. The first is the advancement of knowledge. And what I've said to you is actually to the extent we have knowledge in any sector of the United States, it doesn't function on a marketplace of ideas theory, so that's wrong. Second is the autonomy theory, which is we need to speak in order to fulfill ourselves as autonomous human beings. And the problem with that is, well, we speak all the time. There's a case now up before the Supreme Court Masterpiece Cake Shop theory, where a baker who refuses to make a cake for a gay wedding says, cake is my expression, it's my autonomy. So it's basically a libertarian theory, and since everything we do as human beings is expressive one way or another, it entirely can't correspond to actual First Amendment doctrine. It tells you nothing. And the third is this democratic theory. Those are the three major candidates on the table.
Thank you.
Thank you very much for your talk. I very much appreciated your distinction between the First Amendment in the public square and the First Amendment on campus. I'm concerned, though, let's just imagine a thought experiment where the educational doctrine of a university, which is given to it by its owners, and in the case of a public university, that's effectively the legislature, let's say that that theory is that ideas expressed by Republicans are smart and ideas expressed by Democrats are dumb. Can the university then say, students are welcome to invite Jeff Sessions, but not Eric Holder, because Eric Holder is a member of a stupid political party which will miseducate the students? Is that in keeping with your sense of the First Amendment on campus?
Yeah, that's a very good question. And insofar as what I've said to you now, I couldn't have a response to your question. There's an additional wrinkle which I haven't talked about here. I have a book called First Amendment for the Administrative State, Democracy, Expertise, and Academic Freedom. And in it, I argue that there are really two different goals to the First Amendment. The first goal is democratic self-determination, and that leads to the First Amendment of no content discrimination, et cetera. That plainly doesn't work in a university. There's a second goal, which you see in many of the court's cases, and most strikingly in its commercial speech cases, which I call democratic competence, which is democratic citizens need to know things in order to be democratic citizens. So the ability of the state to distort knowledge is actually constitutionally limited, and this is one of the goals of the First Amendment. I spin off work by Claude Lafleur on what is totalitarianism. Totalitarianism is when the sphere of power and the sphere of knowledge collapse into one thing. If the state could tell you what you know, then the meaning of the state being determined by you becomes incomprehensible. So at some point, knowledge as a sphere has to maintain itself separately than the sphere of power. And that means deference to what I was calling in this talk, academic freedom, is somehow built into the First Amendment. And academic freedom here being understood as the exercise of state authority in ways that are inconsistent with professional understandings of knowledge. And I don't mean to say one trumps the other. One has a constitutional tension there that has to be played out, and that would be played out in the kind of example you put on the table.
So is the answer going to depend on whether Eric Holder is in fact a dummy? I mean, is it like, you could say, so the academic community could say, we're not going to keep out Democrats because they're a mainstream party, but the Nazis are different.
Well, it would turn out this way. I don't know about that. I mean, let's just take you have a biology department, and your legislature says, you have to teach creationism in the biology department. And the biology in the university says, no, This is not competent biology. Under the theory I just gave you, the First Amendment would protect the university's resistance as against the state to do that on the basis that this is the difference between competence and incompetence. So, a simple example would be you get a professor who gets denied tenure, and this professor thinks that they're a genius and the mistake. When I was chair of the Academic Freedom Committee at Berkeley, this is a true case. I had a professor who was in the, I won't tell you what department, but he brought an academic freedom complaint because the department didn't let students major in him. His work was so paradigm shifting that it should be a whole major in him, So what do you know about this field? I don't know from this field. So how am I know whether it's that? So you make your call based upon expertise. So I think you're going to have to. So in a professor, he claims, I'm so paradigm breaking that the professors who tenured me didn't give me tenure, didn't understand how path breaking. I'm the Einstein. They're the jerks. Whatever. So a court's going to he brings suit in a case, and a judge has to decide, let's say, academic freedom on this. How does the judge decide that case? Well, the judge decides whether there was a violation of the relevant rules of professional competence. So if he thinks that this was discrimination against the professor because he supports Trump, as distinct from the work being very good, then he will decide for the professor. If he thinks that the work is kind of bad, and how would he know that? The judge will know that by calling experts in the profession, then he will decide for the university. So what does that mean? That means that in such an instance, what the court is truly upholding are the proper application of the appropriate rules of professional competence. And that's the object of constitutional protection here.
Next.
Good morning. Like John, I know very little about the First Amendment because I'm a dispute resolution teacher. So, but I really enjoyed hearing a structure focused on academic freedom. And you've been a dean, but practically speaking, I would see it as very difficult for a leader of an institution right now today to point to that. I'm a director at the Ohio State University, Moorhead College of Law. I have to say "the" in that way. And they have recently turned down Richard Spencer as a speaker based on safety, right? Safety concerns. And I'm an alum of Cal Berkeley, where Napolitano, the UC president, recently said, we're gonna spend $600,000 to allow Ben Shapiro to speak. And my sense is that it's very difficult to go to the place where you're going and saying we can keep people out for this purpose.
Yes, it is. I mean, and if I were a lawyer and I were advising, I'd say, unless you have in place policies that you've actually applied consistently over time and they can justify, then you're going to need these other quote-unquote viewpoint neutral things like safety, although, the agitators are not letting you get away with that. You see Sessions saying, oh, the heckler's veto, go spend $2 million, go spend I remember as a dean, I once asked the Pope to come give a lecture, and then I was told $1 million of security. Like, no, no, I can't afford that. There are limits to that, but they're not going to let you get away with those limits. A court might let you get away with those limits. But I think on the whole, universities have abdicated this responsibility to supervise what their students are doing, and they haven't thought why. They've just sort of given it to students. They've given their facilities to the public, and they haven't actually created the policies that would allow any other defense. And so now they're reaping the whirlwind of that.
If I could just ask one follow-up on that.
Of course.
I think that would be beneficial to not abdicate. So I really like that idea. What do you make of the way that universities have handled these sort of incidents, like the song on the bus by the fraternity, or the University of Oregon situation where a law school faculty member wore blackface and 26 faculty wanted that person to resign? Or at Yale, with the situations that they've gone through, how would you come down on dealing with those situations?
All right, so let's put aside the legal ramifications of the First Amendment. Just as an administrator, my view of all of these things is you turn them into teaching moments. and you try to, as best you can, bring the parties together, educate them to what's at stake, and reaffirm the community of inquiry and of education that you're there to do. And to the extent that you can turn these occasions into an ability to reaffirm it, that's success. And the problem is when people get backed into these corners of principle, as a matter of principle, you have to fire the Christakises, or as a matter of principle, you have to expel the students. That's when you're in trouble, and so you have to back them out of the principle. Because if you're in a situation of education, education isn't a matter of these rights. Rights don't contain within them, typically, an educational philosophy. And educational philosophy is very supple. It's very context dependent, and it's very hard to squeeze into a framework of these rigid rights, which the principled folk, will try to impose on you. So the object of me as an administrator, always in these situations, is to try to get out of that box and trying to get people to see, actually, there's a complex situation here, and the real point would be, as you saw earlier, the maintenance of the underlying mission and values of the institution. That means retaining the trust of students and the confidence of faculty there's a lot of constituencies that you have to deal with here, and many of them have different points of view. You have to bring them together. You have to somehow reaffirm the transcendent point of the institution as a whole. And there's no mechanism for doing that. That's what Phil Selznick would call leadership.
Thank you, Professor Post, Professor Wells. I'm a faculty member in the School of Journalism. I'm wondering if this analysis this framework that you're proposing today applies to the press clause analysis of student journalists at a public institution, and how that might square with cases like Hosty versus Carter, or whether Hazelwood might apply to the college level.
So I think the press is a different phenomenon than what I'm saying. The press, we can imagine that the press clause is just simply subsumed under the free speech clause. And part of the problem with the Supreme Court since the 1970s is that it doesn't understand a separate value for the press clause. So it just says the press have no rights other than ordinary speakers. And if you collapse the two clauses, then it becomes very hard to know what to do with the press, except you just happen to be speaking in a newspaper. I think that's an inaccurate understanding of the clause. I think there are at least two understandings of the press clause which are valuable and then should be translated into the educational setting. The first is the press is an institution that checks the government. This is Vince Blasey and the checking function. The press is like Alexander Bickel once conceptualized it as a balance of powers, except it's like a fourth branch of government outside the government. And I think that's certainly what the framers did, not that that should be privileged, but you have to understand the press as an institutional presence that has as its interests a kind of adversarial relationship with the government, and that adversarial relationship needs to be protected, and that has a lot of doctrinal consequences, which wouldn't be true in a pure free speech. And second is that the press is the structural precondition of the public sphere, because the public sphere exists when strangers are exposed to the same stimuli. So the public sphere begins to exist with the creation of the printing press. It comes into its full meaning with the creation of newspapers in the 18th century. And Tarde, who develops the idea of the public versus the crowd, says, say, in the early 20th century, the public sphere consists of, it's dispersed, it's not like placed like a crowd in one square. It's all these people sitting in their homes reading the same newspaper and imagining themselves as a public. And that seems to me crucial, that you have the circulation of newspapers or of the press in order to make the foundation of that. That's why, in my view, like Google needs to be treated like the press, because it performs that same sociological function of underpinning a public. Now, if you're in a journalism school, what are you teaching? You're teaching how to do these things, how to be adversarial, how to circulate in ways that are unrestricted, and therefore, it'd be very hard for me to imagine doing your job unless you were teaching these things. Now, maybe you have a different kind of press. Maybe it's, the Catholic press, or I don't know what the answer would be, but because I don't know journalism schools. But it's imaginable to me that you could have a different mission, and then you'd have to talk about whether that'd be acceptable under the First Amendment. But in a public university,
it's going to be hard to imagine a different mission to me. I don't know.
Hi, I'm Jennifer Brown. I'm the Dean of the Law School at Quinnipiac University. And Robert, when you were talking about the university's ability to regulate offensive speech in the classroom, I thought I heard you make a distinction between offensive ideas that should be tolerated on the one hand and personal offense, which can be limited and disciplined. And I just wonder about the cases that are not so distinct. And do you see situations where those two categories blend, at least in the lived experience of students, so that certain materials that would be brought into the classroom, things that everyone is assigned and required to read, would seem to target individual students or question their legitimacy as learners in a way that would make it perhaps something we ought not to tolerate, or at least have a conversation about?
Right. See, this is where I would say I totally agree that these things blur, but I myself would stand very firmly on the idea that offense can't be determinative when you're dealing with ideas. So in a law school, as you know, you teach a lot of very controversial subjects where a lot of people feel extremely vulnerable. You teach rape. You teach affirmative action. You teach abortion. You teach things where any number of students in the classroom, qua members of this group or that group, are going to feel offended if certain ideas are put forward. And yet the function of the education is to, if a function, and I would say it is a function of a public university, to teach students to be democratic citizens. They're going to have to learn how to deal with those ideas, however offensive they find them, qua ideas. Now here I'm distinguishing manner and substance. You don't get to say it in a certain way. You don't get to poke fun of. You don't get to demean. You don't get to, but that you put forward that this is true, in my opinion, as a general statement. I can't imagine doing half the job one has to do in these controversial subjects unless you're able, and that's a matter of extreme delicacy, to make that distinction somehow. And it can't check what you do in the classroom because that makes things speakable or not speakable depending upon the vulnerabilities as ideas, not as, individual arguments, but as ideas in the classroom. And if your job is to teach about that idea, and many ideas which are controversial need to be taught on and are surrounded in auras of offense, you somehow have to find a way to make that safe enough for the students to engage it. That seems to me my job in the classroom, to find way into them.
Good afternoon. My name is Ada Wilson, and I'm from Auburn University. And I'm just curious about to the extent to which this framework applies to nonverbal speech acts that students in the classroom might find to be offensive, where the person who is executing the nonverbal speech act, such as, for example, a Confederate flag T-shirt, how would this apply based off your framework?
I don't know. I don't know. I'd have to think about it long and hard. Just leave it that way. I think one needs to do what's necessary for the climate of the university, but at the same time, if you, whoa, you okay? That's an important educational consideration, but so is the independence of your students to be able to, and what it stands for. So I don't know. I didn't want to venture off the cuff an opinion. It's a hard problem.
Well, thank you so much.